Care and Protection Order, or CPO. The Cpo Application Process. A CPO is a court order that serves to keep children and young persons below the age of 18 in need of care or protection safe. Before applying for a CPO, the Director General of Social Welfare or Child Protection Officer from the Ministry of Social and Family Development may A. Remove the child or young person from their home to a place of temporary care and protection, or B. Present the child or young person before a registered medical practitioner or approved welfare officer for an assessment of their health and any necessary treatment. When is a child or young person in need of care and protection? A child or young person is in need of care or protection if he or she has no parent or guardian, has been abandoned by their parent or guardian, and no other suitable person is willing and able to care for him or her. Has a parent or guardian who is unable or has neglected to provide adequate food, clothing, medical aid, housing, care, or other life necessities for him or her, is unfit or unable, or has neglected to properly supervise and control him or her, which causes him or her to fall into bad company and be exposed to danger. Has been or is at risk of being ill-treated by his or her parent or guardian, by any other person whom the parent or the guardian has not protected him or her from, needs to be examined, investigated, or treated for the purpose of protecting his or her health and well-being, suffers or is likely to suffer from emotional harm because of emotional or psychological abuse by his or her parent or guardian, has or is believed to have a relevant offence committed against him or her, is in danger of a relevant offence being committed against him or her by his or her parent or guardian or another member of the household, behaves in a manner that is or is likely to be harmful to himself or herself or to any person, and his or her parent or guardian is unable or unwilling to take necessary measures to remedy the situation, or the remedial measures taken by the parent or guardian fail, is found to be homeless and unable to support himself or herself, begging for money and food, carrying out illegal lotteries, illegal hawking, gambling, or other undesirable activities, using or inhaling any intoxicating substance as defined in the Intoxicating Substances Act. There are 3 steps to applying for a CPO. Step 1. The Director General or the Protector files a complaint on behalf of the child or young person in the Youth Court. Step 2. The Youth Court judge will decide if there are sufficient grounds in the complaint to warrant an investigation. If so, the Youth Court judge may call for a social report on the child or young person. The Youth Court judge may also order the child or young person be placed in the care of a fit person or a place of safety while the social report is being prepared. Step 3. A child protection officer will interview the child or young person as well as the parents or guardians and/or any significant others before submitting the social report to the Youth Court. What orders can the Youth Court make? The Youth Court judge will consider the contents of the social report and discuss the case with 2 panel advisors. If the Youth Court judge is satisfied that a child or young person is in need of care or protection, the Youth Court judge may order the parent or guardian of the child or young person to be bonded to exercise proper care and guardianship of the child or young person, order the child or young person to be committed to the care of a fit person for a period of time specified by the court, order the child or young person to be committed to a place of safety or a place of temporary care and protection for a period of time specified by the court, place the child or young person under the supervision of the Director General, a protector, an approved welfare officer, or any other person appointed by the court for a period of time specified by the court. Enhanced Care and Protection Orders. Enhanced Care and Protection Orders have been introduced under recent amendments to the Children and Young Person Act to ensure stability and long-term care for children and young persons in need. The Youth Court Judge may make an eCPO for a child or young person to be committed to the care of a fit person until the child or young person turns 21 years old or for a shorter period specified by the court if the child or young person is under an existing CPO or in the care of a caregiver other than his or her parent or guardian under a voluntary care agreement for a specified period or longer. The parents or guardians are not fit to care for the child or young person. It is not appropriate to return the child or young person to the care of his or her parents or guardians. The Youth Court Judge may also make an order allowing the Director General or a protector or the caregiver of the child or young person to make decisions that affect the child or young person. What if parents or guardians wish to contest a CPO application? If you are a parent or guardian who would like to contest the application for a CPO or an eCPO for your child, you may inform the Youth Court Judge. The Youth Court Judge will give necessary directions for parties to file supporting documents before a hearing date is fixed. At the hearing, the Youth Court Judge will hear from you and the Director General or the Protector or your legal representatives before coming to a decision on the case.